One of the most common charges that is flung against January 6 defendants is the idea of obstructing an official proceeding. This is a standard charge, and it's a serious charge because it carries, in some cases, years and years in prison. Now, there's a second charge that is commonly used against January 6 defendants, and that is simply parading in a public building. But parading in a public building is a misdemeanor, and typically that's going to get you, if prison at all, a very short prison term. So for the Biden regime, this earlier charge, which is the obstruction of an official proceeding, is the way that they have used. They have used it really kind of as a battering ram to go after these January 6 defendants, saying you're facing years in prison, you've got to take a plea deal, or in some cases you go to trial, and by being convicted on this charge, you find yourself facing years and years in prison. Now, recently, there was a very interesting interview. Somebody who was on the jury in one of these January 6 cases was, I believe, on C-SPAN, or at least I heard a recording. And she was talking about the fact that in the jury, she was able to convince her fellow jurors to find defendants guilty on this charge, obstructing an official proceeding. Not because they, in fact, obstructed anything, because people were raising questions in the jury like, what did they obstruct? What was something actually going on when these defendants entered the building? And the juror said, basically, I convinced people that nothing has to be going on. Just by being in the building, they're obstructing a proceeding. So think of the logic here. There's a building, the Capitol. An official proceeding is underway, but the time of it is considered unimportant. It's underway that day. These defendants entered the Capitol. They might have been there for 10 minutes, 5 minutes, 30 minutes. And it doesn't matter if the proceeding was going on at that time. It could already have been halted. It may not even have started. But the very fact that they're in the building where the proceeding has occurred or is occurring or is scheduled to occur is enough to find the defendants guilty. Now, this seems a little dubious on its face, and in fact it is. So in Washington, D.C., a D.C. District Court judge looked at this charge and basically said, wait a minute, this doesn't make any sense, because if someone's going to obstruct an official proceeding or interfere with an official proceeding, they have to take some action related to that proceeding. They have to rush the room, grab the paperwork, start screaming at the people who are engaged in the proceeding. Where is the obstruction? Where is the interference? And so the Biden administration panicked because not only have lots of people been taking plea deals based on these charges, have been convicted on these charges, are serving sentences on these charges, but there are more people scheduled to be charged on these same charges. So this obstruction is actually a critical charge for the Biden DOJ to go after the January 6 defendants. And so they appealed it to an appellate court, and this is a high court, the U.S. Court of Appeals for the District of Columbia. But very interestingly, upon considering this case, the U.S. Court of Appeals has come out with an opinion that's really three different opinions. Now, they overturned what the D.C. District Court Judge Carl Nichols did, and they allowed this obstruction charge to go forward. But when you look at the rationale, you begin to realize that two of the three judges are really not on board with the way in which the Biden regime has been using this charge. So the first judge makes it really clear that there needs to be some sort of criminal frame of mind before you can go after someone on obstruction. Someone must, in fact, intend to obstruct. Just being in the building is not sufficient. And this, in fact, was the original rationale when the law was originally passed. In fact, President Bush, who talked about this was passed under George W. Bush, and he talked about the importance of there needing to be some form of corruption, and there also needs to be a criminal state of mind. And yet, can you really show that, for example, the shaman guy, Jacob Chansley, he pleaded guilty to obstruction? There was no showing that he had a state of mind to interfere with any kind of proceeding. In fact, he said he went in there to do shaman prayers so that there would be a kind of spirit of healing all across the Capitol. That was his motive. And no other motive was shown. By the way, Timothy Hale spent 16 months in the D.C. gulag before finally going to trial. He was convicted on the obstruction charge. He's now serving a 48-month prison sentence. Matthew Perna committed suicide. He was facing years in prison over this obstruction charge. And now, as it turns out, 2 of these 3 judges are saying this obstruction charge doesn't really seem to hold up. Judge Katsas, this is Judge George Katsas, in a strongly worded dissent, basically says never in U.S. history has this obstruction charge been used in this way. It's usually used when you're trying to obstruct the criminal proceeding itself. So if a bunch of mafia guys are trying to block an inquiry, they're trying to, for example, interfere with witnesses, then they are obstructing justice in that way. They're obstructing an official proceeding, the proceeding being the trial itself. And Judge Katsas goes on to say things like parading or picketing or using a sound truck to, let's say some guys are outside a courthouse or outside a congressional office or outside of a state office where some proceeding is going on, and then they're shouting in a bullhorn. Are they obstructing an official proceeding? And if so, can they be sent to prison for 5, 10, or 20 years? So Judge Katsas goes, we've never applied the law in that way. All of this means that the Biden administration is now in a little bit of a conundrum, because these cases are going to be appealed, and I think they're going to be appealed all the way. And so the question now becomes, if what these judges say is valid, even though they narrowly upheld these obstruction cases moving forward now, I think that there's a possibility that as time passes and as other courts look at this and higher courts look at this, this whole obstruction thing could in fact be ultimately wiped out.